Welcome to the OAH training on administrative law. What is administrative law? The body of law that regulates the operation and procedures of government agencies. Why create an agency? The legislature passes a law and delegates its law-making authority to an agency to make rules in a particular area. It is used for areas that are technical, specialized, or require a large workforce to implement. This relieves the legislature from detailed rulemaking, the governor from direct administration, and the courts from a huge volume of cases. How does an agency get its authority? Every agency has an enabling act. Agencies get their authority from the legislature. You can use www.oah.wa.gov for shortcuts to access each agency's rules and to the Administrative Procedures Act. Let me briefly show you. On the oah.wa.gov page in the Resources tab, click on Legal Research and Resources. You will see that there are sections for laws and regulations. Who makes the laws and regulations? When the legislature makes a law, it is called a statute. And statutes are found in the RCW, which is the Revised Code of Washington. If a government agency makes the law through its delegated authority, it is called a rule or regulation. And rules go in the WAC, or the Washington Administrative Code. What is OAH? OAH is the Office of Administrative Hearings. If a person disagrees with some things done by a state agency, they have the right to a hearing. Before OAH was created, the hearing was held by a judge from that same state agency. When OAH was created, a new structure was set up with some agencies. The appeal hearings were moved and held by an independent judge at OAH. Over 20 state and local agencies covered by the APA refer their appeals to OAH. You can read more about us on www.oah.wa.gov. So where is OAH's Enabling Act? The Enabling Act is RCW 3412-010. A State Office of Administrative Hearings is hereby created. The office shall be independent of state administrative agencies and shall be responsible for impartial administration of administrative hearings in accordance with the legislative intent expressed by this chapter. OAH hearings are informal. The hearings shall be conducted with the greatest degree of informality, consistent with fairness and the nature of the proceeding. You can find the statutes and the rules on that same page on the OAH website, www.oah.wa.gov. Look under that Resources tab. Click the Legal Research and Resources. Scroll down to the Laws and Regulations section. Click on Statutes and Rules relating to the Office of Administrative Hearings, and that will give you the specific RCWs and WACs. Administrative hearings. The APA uses the term adjudicative proceeding to describe the hearing process. You may also hear them called by other terms such as administrative hearings, due process hearings, complaint hearings, grievance hearings, and fair hearings. Government agencies make thousands of decisions that affect people's lives. When you disagree with the decision that agency has made, there's a good chance you have the right to appeal that decision. When you do, you will get an administrative hearing. Administrative hearing versus the courtroom. The justice system means traditional courts to most people. Administrative law is largely invisible in the press and popular media. When you think of a courtroom, what may come to mind is the typical county courthouse, a fancy building with juries, judges in robes, a witness box, and a bailiff. We may think of things on television like Judge Judy or Law and Order. In administrative hearings, there is no jury. The hearing is typically done over the telephone. When it is face-to-face, it is in an informal conference room. There are no robes and no gavels. OAH has no filing fee. In Washington State, often a person's only contact with the justice system may be with an administrative hearing rather than with the traditional courts. In 2015, traditional courts conducted 10,654 trials. In the same period, OAH completed around 24,000 hearings. This image shows that there is an agency action taken. For example, by the Employment Security Department, the Department of Social and Health Services, or another agency that we call at OAH the Specialized Caseload. This would be something like Labor and Industries or Liquor and Cannabis Board. Once they make a decision, a person is able to appeal that decision. Those appeals come to the Office of Administrative Hearings. There is a hearing date set, and that person has a right to have a judge hear their side of the story. The judge decides the facts, applies the law, and then writes an order. If the person still disagrees with what the OAH judge says, then they are able to appeal that decision to a higher authority. For example, the Commissioner Review Office, the Board of Appeals, a review board, or to the courts. The right to appeal. In administrative law, the right to file an appeal comes from an agency rule, a statute, or both. For example, Employment Security Department is in RCW 5032020. The Liquor and Cannabis Board is in WAC 314-55-510. Who does administrative hearings in Washington? OAH is a central panel. We hold multiple types of hearings from multiple agencies. But other administrative hearings in Washington outside of OAH include many other agencies, such as what are listed in this list. OAH handles many types of cases. Just to give you a visual idea, here is a percentage of the types of cases we do. The Employment Security Department is the largest chunk, followed very closely by the Department of Social and Health Services and the Healthcare Authority. All of the other types of cases that we hold are in that smaller 2% slice. ALJ authority. Generally, an ALJ, or administrative law judge, generally an ALJ's authority is limited to determining whether the agency was right or wrong when it issued its decision. The judges do not make the agency's policies. The judge cannot change the agency's rules. The judge is limited to what the law allows them to do. There are very few case types where the judge has authority to create solutions or remedies. Evidence and hearing procedure. Judges will be active in an administrative hearing. They will ask questions. They may ask for documents. Evidence usually consists of witness testimony and written documents. The judges decide the credibility of the evidence. First-hand reports are more credible. The judge may allow a second-hand report of what another person said, hearsay. Our website, www.oh.wa.gov, has a lot of information about what to expect during the hearing process. Burden of proof. In a hearing, one party has the responsibility to present evidence about disputed facts. A party must persuade the judge that their facts, their position, is correct. Sometimes, after a party proves their position, met the burden of proof shifts to the other side. For example, the burden may shift to prove a defense. The judge will let you know who has the burden of proof. An example from unemployment insurance. If the employer fired the claimant, the employer has the burden to prove the employee's actions were misconduct. If the claimant quit, the claimant must prove they had good cause to quit. An example from child support. Both parents have a burden to prove their income if they disagree with the amount that the Division of Child Support shows. Standards of evidence. These are the standards used by judges when determining if someone met their burden of proof. Preponderance of the evidence. This applies in most administrative hearings. It is the more likely than not standard. It is the more than 50% standard. There is also a standard of clear and convincing. This applies in certain cases like fraud. It means something is substantially more likely than not. Then there is beyond a reasonable doubt. This is not used in administrative hearings. It is used in criminal cases. Ex parte communication. The judge usually does not communicate with only one party. There are exceptions. The first is when communication is necessary for the procedural aspects of maintaining an orderly process. For example, a request for a continuance or a change of location. The second is when the communication is authorized by law. For example, when there is a request for an ADA accommodation. Can a witness talk to the judge anonymously? No, they cannot. Can you write a letter with evidence for the judge's eyes only? No, you cannot. Everything you send or say to the judge must be shared with the other party. That's part of the law. When does the administrative hearing process end? Initial orders end the process only if no one appeals. There is still a right to another administrative appeal. If no one appeals, the initial order automatically becomes a final order. If an appeal is filed, the process ends when the review judge issues a final order. Final orders end the administrative process. An agency can delegate their final decision-making authority to the judges at OAH. An agency may keep the final decision-making authority. Whoever has final decision-making authority will issue the final order. The next step after a final order is to the traditional court system. There are different paths to get to the final administrative order. Some final orders are done by OAH, such as for child support cases and food assistance cases. Some final orders are done by the head of the referring agency or someone they delegate. For example, the Department of Social and Health Services, it is done by their Board of Appeals. For the Employment Security Department, it is done by their Commissioner's Review Office. Another example is the Liquor and Cannabis Board, who do their own final orders. Here is a visual of that. If a person appeals, their appeal comes to OAH. The judge makes a decision. If it is an initial order, it can be appealed again to a higher authority, such as the Commissioner's Review Office or the Board of Appeals. Then they will make a decision that will become a final order. In a few cases, OAH can go straight to writing a final order. Either way, once there is a final order, those orders would need to be appealed to a higher authority like the State Superior Court. Excuse me, there we go. So then what? Once the final administrative order is issued, parties have a right to appeal through the traditional court system. That would be Superior Court or Federal District Court. How do I learn more? You can always learn more by reading the Washington Administrative Code, WAC, and the Revised Code of Washington, RCW. The OAH website has links to precedential administrative decisions that you can read. There is lots of information on other agencies' websites. Washington Law Help is another place where you can learn more. Your two primary resources will probably be the OAH website and Washington Law Help. Thank you for taking this training. We encourage and appreciate feedback to improve any of the training videos and materials. We'll see you in the next video.